Hello, I'm Mark Flowers, a partner with Davies Howe. On May 2nd, the Honourable Steve Clark, Minister of Municipal Affairs and Housing, introduced More Homes, More Choice, Ontario's Housing Supply Action Plan, and introduced Bill 108, an act to amend various statutes with respect to housing, other development, and various other matters. BUILD and the OHBA have produced a series of short videos to help the industry understand the impacts of the proposed changes on the market, practices, and businesses. This video will focus on the impacts of Bill 108 on the Ontario Heritage Act. Bill 108 proposes a number of amendments to the Ontario Heritage Act, many of which represent substantial improvements for the development industry. The proposed changes will level the playing field by increasing the rights of property owners through various means. Among the most significant changes are replacing the existing abilities to refer certain matters to the Conservation Review Board, known as the CRB, with the right to appeal such matters to the Local Planning Appeal Tribunal, LPAT, for a binding decision. This change is particularly important given that the CRB is only empowered to make recommendations to municipal councils, with the municipality retaining final decision-making authority. By contrast, on an appeal to LPAT, the tribunal would have the authority to issue binding decisions, including those that would overturn the decision of the municipality. Among the matters for which new appeal rights to LPAT would be created are the following. First, a municipal decision to proceed with a heritage designation bylaw or an amendment to an existing bylaw for individual properties would now be appealable, with the tribunal having the authority to repeal or amend the designation bylaw. Second, where a heritage designation bylaw already exists, the property owner may apply to the municipality to repeal the bylaw. If the municipality refuses to do so, that decision will now be appealable to LPAT, with the tribunal having the authority to repeal the designation bylaw. Third, where the owner of a property that is subject to either a notice of intention to designate or a designation bylaw wishes to alter the property in a manner that is likely to affect the property's heritage attributes, a refusal of the application by the municipality or the imposition of terms and conditions will be appealable to LPAT, with the tribunal having the authority to order the municipality to consent to the alteration, with or without terms and conditions that it may specify. Turning then to some of the other proposed changes. There is already an existing right of appeal to LPAT for a binding decision from an application to demolish or remove a building or structure from a designated heritage property under Section 34 of the Act. However, Section 34 is proposed to be expanded to include the demolition or removal of a heritage attribute, allowing a property owner to apply to demolish or remove a heritage attribute that are neither building nor structure. An example might be a heritage tree. Bill 108 also proposes to incorporate more specific timelines into the Heritage Act, designed to ensure that matters move more quickly through the system and that municipalities are more accountable for their actions. For example, where an owner applies to a municipality to alter a designated property or to demolish or remove a building structure or a heritage attribute on a designated property, it is proposed that municipalities will need to advise the applicant within 60 days as to whether or not the application is complete, failing which it will be deemed to be complete. Through regulations, the province will also be able to establish submission requirements for complete applications under the Heritage Act. Also proposed are timelines for municipalities to pass a heritage designation bylaw following the issuance of a notice of intention to designate. More specifically, municipalities that choose to pass a designation bylaw will need to do so within 120 days after issuing a notice of intention to designate, subject to certain limited exceptions as may be set out in regulations. Another important new timeline for the development industry is a proposed 90-day deadline in which municipalities can issue a notice of intention to designate following a prescribed event. And although we do not yet know what those prescribed events will be, the Ministry has advised that it is anticipated that these events will be the submission of certain planning applications by property owners, and that the new provision is designed to address the all too often practice of municipalities waiting until very late in the development application process to propose a heritage designation, sometimes taking that action shortly before a decision on the planning application is to be made or an appeal hearing is to be held. Bill 108 also proposes to introduce required notice to property owners where a municipality elects to list the property on its heritage register. The notice would need to occur within 30 days of the listing, and owners would then have the right to object to such listing by filing a notice of objection with the municipality. However, unlike other matters where there are rights of appeal to the LPAT, the decision to either list a property on the register or remove a property from the register will remain with the municipality. And finally, the bill proposes to give greater provincial direction to municipalities with respect to certain heritage matters. First, when making certain decisions on individual properties that are designated under Part 4 of the Act, or for decisions with respect to properties within a Heritage Conservation District under Part 5 of the Act, municipal councils would be required to consider certain principles that are to be established by the province through future regulations. Secondly, through regulation, the province will give greater direction to municipalities regarding the content of heritage designation bylaws. And although outside of Bill 108, the Ministry has also announced that in parallel with these legislative amendments proposed, it intends to provide enhanced guidance to municipalities regarding cultural heritage landscapes, with the objective of providing a clear process to protect cultural heritage landscapes, while at the same time allowing for sustainable and compatible development. In terms of implementing these proposed changes to the Heritage Act, Bill 108 proposes that the amendments would come into force on a date to be proclaimed by Cabinet. We do not yet know what the expected timeframe might be, except that the Ministry has advised that it does not currently contemplate bringing the proposed changes into force until such time as all of the anticipated regulations have been developed, and recognizing that there may be a number of logistical matters to be resolved, as appeals for many municipal decisions will now be directed to LPAT rather than the CRB. One of the key regulations will address transition matters, setting out how existing applications under the Heritage Act will be handled going forward, and possibly including currently matters that are before the Conservation Review Board. The Ministry has told us that they will be developing the regulations in the latter half of this year, and that this will be a fully transparent process, with drafts of the regulations being posted for public comment, and there will be opportunities for stakeholders, including BUILD, to meet with Ministry staff to discuss the proposed new regulations and provide feedback. BUILD members should be very pleased with the proposed changes and proud of the contributions it has made to shape this bill, as it reflects a swinging of the pendulum back in favor of a more balanced system of heritage protection with specific measures designed to hold municipalities more accountable for their actions and decisions. At the same time, there is still much work to be done. Given that so many of the changes rely on future regulations that have not yet been developed, and given that future heritage decisions by municipalities will be guided by the content of those regulations, BUILD members need to stay active in monitoring, commenting on, and ultimately helping to shape the content of those regulations. As the government turns its attention to regulations and implementation, BUILD, OHBA, and of course Davies Howe will continue to keep the industry informed of developments. On behalf of OHBA and BUILD, thank you for being a member, and thank you for your support. If you are interested in learning more or have questions, please contact Paula Tenuta at ptenuta@buildgta.ca or me at markf@davieshowe.com.